SJC-13175, Michael J. Bassichis v. Michael I. Flores.
Great. Attorney Farber, we're ready for you.
Yes. Can the court hear me?
Yes.
Yes. Okay. May it please the court, my name is Peter Farber, and I represent the plaintiffs in this action. First of all, I would like to thank the court for taking this appeal sua sponte. If I am correct, the last time the court addressed the doctrine known as the litigation privilege was in 1991 in the case of Corellis versus Viveras. That case had been decided on a Rule 56 motion that the statements were absolutely privileged statements to the police, and this court affirmed that. The instant case requires the court to analyze the privilege as it relates to attorneys conducting litigation in the courts of the Commonwealth. This brings into focus not only the policies supporting the doctrine of absolute immunity based on communicative acts, but also the standards which govern the conduct of lawyers as officers of the court. My presentation will address three major points. First, an observer may say that there's a collision here of two rock-solid principles of law, one being the doctrine of the litigation privilege, which is said to be as old as the adversary system itself. The other principle, which is of equal pedigree, is that the courts do not tolerate the manipulation of legal proceedings by an attorney or anyone else to accomplish illegitimate or illegal ends. The plaintiffs see no collision in this case, much less a collision that results in a litigation privilege carrying the day. The gravamen of this complaint is that the defendant attorney, in conjunction with his client and her husband, employed the court system to perpetrate a fraud on the husband's creditors, and attempted to hide this fact behind 203 findings of fact, which were drafted by the defendant and presented to the court as agreed upon findings. There was little, if anything, in the testimony at the trial or in the 21 uncontested exhibits that support any of these findings.
Although the lawyer was pretty explicit about what he was doing. He goes into court and says, I don't know what he was thinking, but he goes into court and says, hey, I can't do this by consent. I need to have a hearing here, and you need to, basically take 100% of the, give the wife 100% of the assets, right? He states what he's doing. It seems like that may be an abusive process in and of itself, but he is expressly stating that right up front, isn't he?
He certainly is, Your Honor. And if I were a fly in the courtroom, I would suggest that Judge Gandor probably says, well, the creditors aren't involved in this proceeding, and there's nothing I'm going to do in this proceeding is going to affect their rights. So go ahead, Mr. Flores, and proceed. But obviously, I was not in the courtroom and could not understand why the Judge Gandor did not respond to that opening remark.
So then, although it's not pled as an abusive process, that's the best theory for it, isn't it? That the divorce proceedings are being manipulated to provide bankruptcy protection. Is that essentially your argument?
Well, both bankruptcy protection and protection in the suits that were already ongoing in the Superior Court. Mm-hmm. Certainly the defendant was aware of those suits. And in fact, the judgment, there was a proposed judgment filed by the defendant on the day of the trial, or certainly the morning after. But proceedings in the Superior Court, when it was evident they were throwing into contest or challenging the ability of the Von Thadens to obtain relief from those judgments or those suits. The defendant went back into court with his proposed 203 findings of fact, These were filed after the judgment ended. If you look at the docket, which is attached to one of the amicus briefs, they were filed, I think, in late August or in September. The judgment had already entered in July. So literally what Attorney Flores was seeking to do was cover his tracks and get some findings into the record, so that as to mislead others, certainly a judge of the Superior Court being one, that this was a fully contested case, and the judge had made these 203 findings when it was obvious it was a consent judgment. It was not an adversarial case at all, and it was essentially a manipulation of the divorce proceeding.
What do we make of the, go ahead. Mhm.
I guess I'm trying to figure out, if we adopt the appeals court Gillette decision and make a differentiation between conduct and statements, what is the conduct that Attorney Flores engaged in separate and apart from his statements that you're basing your allegations on? And the reason I ask that is because my understanding of the privilege is that even if statements are made in bad faith and unsupported, those are privileged, absolutely privileged. So how do we, unlike Gillette, which apparently threatened suit and filed suit in order to obtain a business advantage, what is your theory that, of Mr. Flores here that's separate and apart from his statements?
I think the court, in the number of decisions the courts have said, it's not always easy to determine the difference between conduct and statements.
Right, and so that's the problem with your position, because we want lawyers to be able to advocate on behalf of their clients. Here, the lawyer was very open in what he was trying to obtain, and not hiding the ball and not using the system secretly to obtain an advantage like Gillette was doing. And so I'm wondering, how we avoid that slippery slope. We want lawyers to be able to advocate strongly on behalf of their clients in judicial proceedings. We don't even have a quasi-judicial proceeding. We actually have one. So,
yes, I understand.
Yeah, so what is the limiting principle here that wouldn't, chill effective advocacy?
I would say, Your Honor, that if the litigation privilege, if you take it to its real core, it's to protect the content of statements originating with defamatory statements. There's nothing in the content of the 203 findings of fact that is in any way defamatory. This case would not have provoked retaliatory lawsuit by the participants themselves, any witnesses of the parties. So when you look at the policies that are behind the litigation privilege, none of them apply in this case. And I think that's the important thing.
Well, I guess I quarrel with that, because aren't you chilling effective advocacy if suddenly statements that attorneys make on behalf of their clients can be used against the attorney in a suit just like this one in order to reach a deeper pocket that's now available under your new theory? I guess, I understand the Gillette case, which was, Gillette trying to quash startup companies by forcing a disclosure of baseless litigation and scaring away investors. That's a different theory than what you're suggesting here. Here, you're actually saying, yes, the attorney was quite candid with the probate court in what he was trying to obtain and how he was trying to protect the assets for the wife. And he needed an adversarial judgment. These are things that maybe, Yeah, I guess I'm searching for the principle, and I get it's fact specific. But if we adopt your position, isn't that really going to chill advocacy? Because then it's an unknown. Anytime I get in front of a tribunal and I say something that might benefit my client financially, I may be subject to, a lawsuit someday that maybe on summary judgment, maybe I win, but I get to, get dragged through litigation for some time.
Your Honor, I think the behavior or the conduct of the lawyer in this case is so far beyond what after 35 years I find acceptable in the court. I don't think this is a hard case because the gravamen.
Unacceptable for a lawyer to define a legal strategy to preserve the client's assets.
I think certainly between the parties themselves, the attorney is accorded, the full benefits of litigation privilege. I think, though, that when it involves a manipulation of the legal process, and I will be very candid, I think that's exactly what occurred here, and it was an effort to disguise what was essentially an agreed upon case, a consent judgment, to make it look to the world like it had been the result of a judge actually rendering a decision after hearing competing facts, whatever. There was nothing for the judge to decide here. And a review of the transcript, which I know this court doesn't have, is clear that he was just saying, so you agree with this, Mr. Von Thaden? Absolutely, Your Honor. Absolutely, absolutely. There was nothing for the judge to do.
Besides Gillette, because I mean, this is tricky because lawyers are officers of the court too. They don't get to lie to the court. They don't get to defraud the court. So I'm trying to understand sort of just what Justice Wendland's probing is, where are the boundaries? Although I think there are greater boundaries maybe than Justice Wendland thinks. Because are there other cases besides Gillette where we've got abusive process and we're holding the lawyers as opposed to the clients accountable for the abusive process? Do you have some good examples there? Because that would be useful.
Well, I think I cited the major cases in my brief. I think I could go, if I were to go further, I would identify the cases under Chapter 109A, which clearly is a policy long recognized in the Commonwealth, if not countrywide. I've cited the Northborough National Bank case versus Risley, and that case cites various other cases where the participant in a fraudulent or alleged fraudulent transfer of assets is found to be equally liable and must return, or certainly is subject to the disgorgement of any assets that he or she receives. So I think there are not a lot of cases.
We're dealing with here. The tricky issue is the lawyers, right? I mean, the things that seem similar to this are the anti-SLAPP cases and the process cases, but I'm looking for examples where you get to sue the lawyer. That's what, that's what sort of, because this seems to fit comfortably within an abusive process potentially, or even, something worse. But again, the lawyer, it's when we deal with the lawyer, I'd like more examples. Where we hold the lawyer accountable.
I think the court has to focus on the gravamen of the complaint. If you review the complaint that was filed in this action, it focuses on the attorney's conduct and the the statements, and certainly the content of those statements, is just evidence of how he carried out the manipulation of the
Well,
system.
the one thing that struck me is, I don't understand, does he take the money in escrow? I mean, I don't get
Yes,
exactly. So
yes.
he's just holding it in escrow, isn't that's kind of cute, you know? He's not getting the money, he's just holding it in escrow, right? There's nothing wrong with that, right?
Well, I certainly nothing wrong with that particular act. I think the discovery, if it goes on, will show that he kept a good portion of that as his fee. And the 109A does not separate out, distinguish between what the transferee does with his money or the property that he received. So it may be that the case is allowed to proceed. The judge in the Superior Court will order the disgorgement of that if he found that those proceeds should be used to satisfy the creditors. But certainly, going back to your original question.
Yeah, counsel, can you go back to that original question? So you, in response to Justice Kafker, gave a litany of cases of examples. Which one of those were against the lawyer involved?
See, there are none, Judge, that I know of. That in many respects, this is a case of first impression, in the sense that if you review the whole history of the litigation involving the judicial litigation privilege, you don't find any cases that address lawyers.
Well, that's a problem for you then, isn't it? I mean, I mean, even Gillette, is Gillette a lawyer case or is Gillette a corporation case? You know, so that's not so helpful either. I mean, is the remedy the Board of Bar Overseers here and not, you know, is that really where we should be looking as opposed to trying to, you know, gut the litigation privilege? I mean, it would really help if you got a case involving a lawyer. Any case in the country would be useful.
Well, I would say, Judge, in the bankruptcy, there's a huge amount of cases in the bankruptcy realm that address what the parties themselves are doing. But again, they don't address it from the view of the lawyer and what his or her responsibility is.
So
but
you
again,
can't, Mr. Farber, I'm not meaning to be difficult. I'm just looking for support. Do you have any case in the country like the one you're asking us to find here, where the lawyer's conduct creates a separate cause of action?
I mean, in every case, in every area of the law, there has to be a decision of the type you're thinking of. You seem to be wanting to look.
We spend our days when we're not in court dealing with bar discipline. So we have plenty of cases where lawyers get in trouble and we have to deal with that. But this seems novel in a way that I hadn't really appreciated until now.
And if I could, Your Honor, I mean, certainly I'm well aware of the bar discipline route. That of course wouldn't satisfy my clients, because, you know, a violation of a disciplinary rule doesn't result in any judgment in a civil court involving another party that I'm aware of. But what I would say here is the focus should be on the gravamen of the complaint and the fact that this was active participation in a fraudulent transfer, or should I say, that's what's alleged in the complaint. Certainly Rule 12b-6, in my view, should not be the avenue to dismiss this case. The judge did not address any of the facts and just accepted that this is not applicable. And I think that the policies that support the litigation privilege do not apply here. Absolutely do not apply. And certainly the defendants counsel in his brief has not alleged that any of those policies or spoken to any of those policies. In my view, when the litigation privilege is put aside as being not applicable, then what's left is a 109A case. And then you look to the participants, and lawyers are not exempt under 109A if they participate in the fraud carried out against third parties. So yes, it's very much a case of first impression. You know, there always is one in the law.
Can I add one last question? Did you look in 93A
Yes,
and were there cases where the lawyers end up as defendants in 93A actions based on behavior like this? Because that seems to be 109A is that's a fraudulent transfer provision.
yes.
Yeah.
Your Honor.
The lawyer here is not getting any of the money except for he's getting his legal fee. But so were there any 93A cases where they found liability, imposed liability on the lawyers for sort of unfair and deceptive litigation practices?
Well, I would say this, Your Honor, that the 93A cases, and I believe I cited a couple there, they look at whether the attorney's conduct is simply what the courts refer to as traditional aspects of representation of a client. But when the attorney steps away from that and conducts him or herself in a manner, injects himself into the marketplace, which I believe the attorney did here, then he or she could be found liable under 93A. And when you look beyond just the content of the statements, that sort of hits you in the face like a bath of cold water. That's exactly what he did. He in conjunction with his client and the client's husband, they had one common objective, and that was to take this money aside for the benefit of the divorcing spouse that was the client, and that affected the marketplace. It was conducted outside traditional notions of representation. So I'm not sure if the Kirker v. Hill was the case that I cited in my brief, whether that was, but there's certainly cases in here, and I do refer to them in my brief. I believe I did.
All right, thank you. If no one has any further questions,
All
we
right.
will, thanks. We'll move on to
Thank you.
Attorney Chamberlain.
Good morning, Bill Chamberlain for Attorney Michael Flores. I would just like to start with Attorney Farber when he was asked what were the claims of the plaintiffs based on, referenced his complaint, the allegations of the complaint, said that reflected and laid out the conduct, but then he referenced the statements and the content of the statements. And I think even if this honorable court does not adopt the reasoning and the principles set forth in Gillette v. Provost concerning statements v. conduct, the Supreme Judicial Court has a long history dating back to at least 1841 of applying the litigation privilege to statements made by an attorney prior to and during litigation.
Yeah, although if we want to take you at your word, I take it you're quoting the Lemuel Shaw 1841 stuff. Is that right? He uses the word good faith in that. And we've sort of, I mean,
He does, Your Honor.
Yeah. What happens when we've got a classic abuse of process case, but the lawyer's the instrument of it? The clients didn't figure this out. The lawyer figured it out. What do we do?
Well, one, Your Honor, I would suggest that according to the allegations in the complaint, the client did figure it out. The plaintiffs alleged they already had this agreement before they came to.
The client figured out that they they couldn't do a stipulated 100% judgment. Rather, they needed a court to have a hearing and make findings. That sounds like lawyer stuff to me.
What I would, in paragraph 29 of the complaint, Your Honor, the plaintiffs allege that after obtaining a commitment from Mr. Von Thaden, Mrs. Von Thaden, Attorney Flores' client, came to him for purposes of the divorce action. The allegation against Attorney Flores is that he orchestrated the scheme to allegedly implement that collusive divorce.
Right. Well, that's what I mean. I'm not saying this is all true. I'm just saying, but we've got a motion to dismiss here. I haven't read the complaint carefully. Is part of it is this is a fake divorce, that they actually aren't divorced, or is that not a component of this?
That's not a component of it. And in fact, it's alleged that the divorce was caused by an irretrievable breakdown in the marriage.
Can I let me pose a hypothetical then. Say a lawyer basically comes up with a whole scheme. Pretend like you're divorced. We're going to have 100%. You're going to take all of this. And the lawyer helps them do that. And those were the factual allegations. Could you bring a case? Would that be a case that's actionable as opposed to this one? If the lawyer basically structures a fake divorce 100% to one client and basically leaves all the creditors out of luck, is that actionable under this, or is that also not actionable? Is even that protected?
Well, I think it may be protected in terms of the attorney owes no duty to the creditors. That's a separate issue. It's clear that he only owes a duty of care to his client. But in terms of, at least as the litigation privilege is concerned.
I'm just saying that if the attorney wove this whole thing together, basically came up with a way of getting 100% of the assets protected from the creditors and to the wife, but it's really, the whole thing's a fake. Is he still protected by the litigation privilege?
I would suggest that perhaps he isn't, if the claim is based on conduct as opposed to statements,
So
which isn't the case we have here.
So this conduct statement distinction is a good one then?
I believe it is. I believe it's clear, even putting aside Gillette, that statements made by an attorney during litigation are absolutely protected. So does Gillette raise an issue about, well, it's not quite statements, but it's conduct, so could it be liable? Perhaps, but the only conduct we have
compartmentalize the silo those two. You know, we have in another area of law, we have verbal acts where even though words are used, they're considered acts. So the dichotomy is not foolproof. Sometimes people act through words.
That's true, Your Honor. And I know other states, I know in preparing for the oral argument, I came across a 2006 California Supreme Court case that draws a distinction between communicative acts and non-communicative acts, similar to the Gillette v. Provost distinction. In that case, the allegation against the attorney was that he submitted a false declaration of service in a legal proceeding in order to obtain a default judgment and then executed on that default judgment. And the California Supreme Court held that the gravamen of the claim against the attorney was the filing of that false declaration. And given that that's a communicative act and that an attorney's statements in litigation are absolutely privileged, it was held that the litigation privilege applied in that case.
If an attorney engaged in fraud on the court to benefit his client, but all the fraudulent statements are done in court, is that actionable? I mean,
I would submit that it might be subject to discipline or sanctions from the court, certainly perhaps from the BBO, but I don't believe that it suffices to create a cause of action. And nor do I think that if it did, that the litigation privilege would not operate to preclude civil liability. There could be other forms of liability, but not civil.
No matter how extreme, wrongful conviction, the prosecutors using the court to frame somebody. It doesn't matter how abhorrent the behavior is. If you are using the courts as an instrument to commit a fraud, what you say in court is 100% absolutely privileged.
Under existing Massachusetts law, Your Honor, what you say in court is 100% absolutely privileged in terms of civil liability. I don't think there's any decisional law that provides otherwise.
So if the lawyer, but the lawyer leaves an email, or he leaves some statement on the client's phone saying, we're gonna fool the court. We're gonna pretend like you're divorced. You're not gonna be divorced. We're gonna give all the money to your wife. Is that severable because the conduct isn't it? There's some evidence of conduct outside of the courtroom or statements outside of the courtroom?
I don't believe so, Your Honor, because again, I would submit that that's not conduct, and it's the litigation privilege applies to statements preliminary to, in connection with, and during litigation.
What is the appeals court saying then when it's talking about conduct in Gillette? And there's another case too. There's the Gillette. There are two cases where they draw this conduct.
Well, certainly in Gillette, it's the conduct of filing an allegedly baseless complaint, which caused damage to Shave Logic because it had to disclose that to its investors.
Mhm.
It didn't matter what was in the complaint. It wasn't based on the content of the complaint. In our case, it's the content of the argument and representations made by Attorney Flores to the probate court that form the basis of the plaintiff's claims. It's not the mere filing of suit, and it's not even the alleged collusive agreement. That didn't damage the plaintiffs. As Justice Gilday, in my opinion, correctly determined, but for these alleged misrepresentations to the court, this divorce judgment would never have issued, and the plaintiff creditors would never have been damaged. So it's based on the content of statements. It's not mere conduct of filing the divorce. Nobody's saying the divorce couldn't be filed. And if, again, the allegations of the complaint, where it explains what the plaintiffs mean by orchestrated a scheme, it talks about or relies upon, sorry, go ahead, Your Honor.
I'm just, again, then I'm looking at Millennium, the abusive process cases. So the three elements of the cause of action in an abusive process, fact finder must find the process was used to accomplish some ulterior purpose for which it was not designed or intended, or which was not the legitimate purpose of the particular process employed. So even if we find the lawyer is orchestrating an abuse of the legal system, I'm not saying your client's doing that here, but
Understood.
there's no, the lawyer is protected in that regard, as long as I'm trying to understand that.
Well,
then,
I don't.
are we
I
wiping
don't
out
think-
the abusive process tort for lawyers? Because lawyers are part of, I mean, maybe we are. I mean, I don't know.
I don't think affirming the judgment in this case would result in that, Your Honor. Again, the one, abusive process has not been pled in this case. So to me, it's not an issue in terms of the plaintiff's claims. Two,
Right, but it's
I don't know that.
the 12B6, so we sort of take the facts. They don't need to characterize their theory. They just need to put the facts in.
Sure. And I don't know, and I'll candidly admit I haven't researched it enough. I don't know that the plaintiffs would have standing to assert an abusive process claim, because process certainly wasn't used against them. And also, the purpose of a divorce action is to obtain a divorce. That's the exact purpose for what it was used. Again, if it's not based on the content of the arguments and presentation made by an attorney to the court, then I would suggest that the litigation privilege has no applicability. But where it's the argument is you misrepresented to the court the husband's conduct and whether he engaged in dissipation of assets, which resulted in this allegedly improper and collusive judgment, that is protected by it. Because to rule otherwise would chill the complete freedom that the Supreme Judicial Court has said an attorney should have in advocating on behalf of his client. if it's something that's not based upon the attorney's argument, the attorney's strategy and attorney's filings with the court, then certainly the abusive process claim would survive, like it would have under the Gillette v. Provost standard if that's adopted.
And the good faith,
Sorry,
no, it's okay. Go ahead.
what can we rely on to police attorneys engaged in this kind of conduct then, if we can't have an abuse process claim or claim by a third party?
Well, the appeals court in the Sullivan v. Birmingham decision stated that we do have built-in controls instead of providing private causes of action based upon statements made during litigation, and that's the judge himself. We do have judicial controls to police this. And as has been noted and stated, Judge Scandora was fully aware of what Attorney Flores' strategy was. So, you know, I mean, he's not named as a party, but there was nothing hidden here. If Judge Scandora had, you know, felt that there was anything untoward going on, certainly it's within his power and ability to either issue sanctions, report it to the BBO, so that disciplinary action could be pursued and assessed. But that didn't happen here. But just to go back to one thing you said, Justice Kafka, in terms of Horvey Wood and the good faith, I believe the subsequent SJC decisions in, I think it was Mazzullo and Aborn, clarified that it doesn't have, the statements don't have to be uttered in good faith. The litigation privilege is absolute, and it applies whether the statements are issued or spoken maliciously or in bad faith.
I know we did that. Just trying to figure out what we mean. You know, is it basically I'm trying to reconcile this conduct versus statement stuff with the fact that we're giving it absolute protection to lawyers, and lawyers act through their words. You know, they're not construction workers. You know, this is how they communicate and how they do their job is, you know.
Understood. Could I provide, I didn't cite it in my brief, didn't come to my attention until I was preparing for oral argument. Could I provide the citation for that 2006 California Supreme Court case?
Sure. Mm-hmm.
It's 128 P3rd 713 Cal 2006. And it does have an exhaustive discussion of statements v. conduct. And the litigation privilege under California law is very similar to ours under Massachusetts law.
And so just to summarize, where do they draw the line and apply their line here? That you say they do allow certain conduct to be actionable. Do they define what, you know, something useful that's relevant here?
They do, Your Honor. And they give examples of what is considered non-communicative and what is considered communicative.
And this is a case involving a lawyer.
It is.
Okay.
A lawyer who allegedly submitted a false statement of service, which resulted in issuance of a default judgment.
Okay.
And then a subsequent levying on the judgment.